Hello and welcome to the Silver Shemmings Ash Construction Law Podcast. I'm Sean Lowthorpe, a business journalist, and I'm joined by two of the firm's construction lawyers, partner Henry Hathaway.
Morning, Sean.
And associate Laughlan Steer.
Good morning, Sean.
Thank you both for joining us. In this episode, we're going to take a look at perhaps one of the most contentious issues of all. That's payment, including recent changes, what to look for in a contract, and most crucially, tips on getting your cash. Laughlan, I'm going to start with you. Getting your cash, that sounds like the most important issue of all.
Well, Sean, indeed, I think that's right. The vast majority of the work we undertake involves getting that cash in one way or another. Certainly, most of our work, the clients that we haven't been paid or are unhappy with the amount that they feel they shouldn't be paying. So certainly money really does underpin the majority of our work. And I think the starting point always in all of this is, what does the contract say? What are your rights there? What are the obligations? And then looking at the mechanisms in there. Do you think that's true, Henry?
Yeah, that's absolutely right, Laughlan. I think that one of the main issues that we always find is generally when a client or a prospective client comes to us with a problem, and 90% of it will be about payment in one way or another. Cash flow has always been an issue. It continues to be an issue. The insolvency rates are quite large, and it comes down to how parties will actually derive the monies to which they feel they have a benefit for. But the problems are inherent right from the start of contract.
And is that the problem, that they're coming to you a little bit late in the process? I mean, is your advice that they need to really be thinking about this before they start?
Yeah, absolutely. Like most of the aspects, like what we're trying to do is we're trying to take a prospective approach, understanding what the contract terms are, how to get paid. If they haven't been paid, and there are issues like that, what are the next steps? And we have to get to the answer in respect of what each party has to do in order for the next steps. The contracts and the case law behind that offers quite a number of solutions. It's about the application, the understanding, the knowledge. Through our seminars, that's what we are trying to get the message out. Ultimately, what we do find is that parties do wait too long. We still have an instance in construction whereby parties are, one sense or another, they're afraid of coming across as too contractual. Ultimately, there are ways to deal with that. Payment is provided for, but it's understanding how those rights accrue.
And Laughlan, why are they waiting too long? I mean, given the sums of money that might be involved here, why do you think people are sort of sitting on their hands, if you like?
Well, I think that's a very interesting point, Sean, because we have some clients who they'll come to us and perhaps the contracts haven't even been fully negotiated yet, but works have been undertaken. We see that as being a real problem, where actually it's not necessarily certain what the rights are despite work already being underway. And sometimes if there's a big difference between the client's account and then their employer's account on a job, I've seen differences of several millions of pounds in a stage where it's not even that certain what the rights and obligations are. Now, as Henry very rightly said, if we can get clients in and speak to them in a prospective way at the start, and get everything executed and sorted out then everyone knows exactly where they are. And I think that's the key point to make sure everyone's prepped.
And I think Laughlan, absolutely right. And there is an understanding, like from experience, Sean, I'm a civil engineer. I spent 12 years working in the industry before I became a solicitor. And during the course of events, when I did work for contractors, for developers, it was very indicative as to why these problems actually arose and why and how they actually continue to exist. And it's from that direct experience that hopefully as a solicitor that we can actually get to the root of these issues.
I mean, let's just pin that down a little bit. I mean, can you just sort of clarify some of the specifics of this, what we're talking about?
Yeah, of course. I think the introduction of the Construction Act was actually very key, because one of the key concerns there was cash flow in the industry. One need only think back to the case of Carillion to show that actually even a very large contractor can fall foul of this and the inherent problems with cash flow in the construction industry. Now, some of the important provisions that were brought in include the abolition of pay when paid clauses. It was previously commonplace where the subcontractor would effectively be held to ransom by payments being withheld further up the contracts chain. And of course, That is now outlawed. However, of course, that doesn't stop canny individuals amending their contracts to elongate payment cycles, which is something to look out for, either to focus on if you are higher up the contract chain, or something to be aware of if you are further down the contract chain.
You mentioned sort of Carillion there. I mean, these changes, these Construction Act changes that you talked about, do you think that would prevent another Carillion from happening?
I think the events of what actually occurred with Carillion, when you look at the different reasons, like, it was all Construction Act compliant. And that's the one aspect. There are contracts where would have been, quite okay if it had been tested. The point, like Laughlan's completely correct on that basis, is how the amendments or how the actual contract provisions extend out the timelines to, quite frankly, give someone very little chance on such an event. And ultimately, what we'd be saying to contractors or subcontractors, or we're saying to the industry as a whole, really is those discrete points as to the payment terms within the contract really do become very important. The cycles are all contained. If they're not contained expressly within the agreement or the contract, they will be implied by statute law. Understandably, then, we do simply have a problem by which every QS, if you ask them, in some instances will say, when is the due date under a contract? Invariably, they will always nearly say the end of the month. So what we have is a stage process. We have a due date, we have a payment notice date, we have a Payless Notice date, and we have a final date for payment. If the contract expressly does not provide for that, statute gets implied.
And those things that you mentioned, are they the things that you should be looking out for in a contract, or are there other things on top of that?
Absolutely, because like one of the payment provisions is that to say under a standard form JCT, unamended, the payment cycle is 14 days, for example. There's nothing to stop a party extending those. And in the case of Carillion, I understand it was 120 days. So quite frankly, anything can happen within those. Furthermore, if a Payless Notice is given the day before that, as I believe the contract and the agreement had at that stage, the payee could be in for quite a surprise, having expended such amounts in reliance that this money was coming, then to be told there is now the Payless Notice. It's down to the agreement, Sean, and ultimately, before parties go into contract, that they must understand their own business, their own cash flow, as how this contract will actually operate in terms of their overall requirements as a business.
Laughlan, I just want to bring you back in here as well. I mean, we were talking about this idea of pay when paid clauses. Now that this as this clause is gone, I mean, are there other tricks that have come in now to replace it?
As we've spoken about, the elongation of payment cycles, and by that I mean, as Henry's referred to, a vast number of days in between payments, such as in the Carillion contracts we mentioned there. This is a real issue. Now, on top of that, what we often see, and I'm sure Henry will agree with me here, is that you'll have three different perspectives on in terms of entitlement to payment. We might look at a document and say, I'm not sure this is what you think it says. And the other party on the other side will be there saying, well, here are the dates that we think apply, and our client may have another opinion. So what we really have to watch out for is any amendments that are made properly, that really take into account all of the timeframes. Clients have to be very, very careful that if they do ad hoc amendments, and by that I mean sort of scribbling on the contract, and maybe they sign it and think that's okay, it might work, but also you run the risk of actually creating amendments that aren't very clear.
Have you got an example of that, where somebody's sort of scribbled on a contract?
I have, Sean, indeed. I had one case not too long ago where someone had just written 30-day payments.
And what happened?
Well, luckily we managed to settle that one, thankfully in the client's favour.
Yeah.
But it was an example of a potentially unclear amendment that led to uncertainty as to the timeframes for payment. And that's the sort of thing that we'd want to avoid by getting in early and at an early stage, looking at the amendments and making sure that they interface correctly with the rest of the contract.
I mean, is that a problem that you've come across as well, Henry?
Oh, absolutely. It's continuous. And even from my own experience within the construction industry, in terms of when payments become due, what are the process? What does a proper application look like? And what should it consist of? And ultimately, what happens if you don't get paid by the final date for payment?
Yeah.
What do we do then? And these are the exact points we've had, and we'll talk about termination in a separate instance or a separate podcast. But one of the main points about it is not to abandon the works. You will be in breach of contract if you abandon the works because you haven't been paid on that basis.
Yeah.
You have to invoke the Section 112 under the Construction Act and put forward a notice of intention to suspend the works. And within 7 days, if they don't pay, then you're entitled to suspend the works.
So you're saying simply downing tools is not the best option?
Absolutely not,
It's a
Sean.
disaster,
And it is absolutely something that we see time and time again, and it is something that cannot occur. What I do think is that each and every business, that for every quantity surveyor, every project manager, every director, those in control of the projects, really do need to, at the start, not at the end, but very much at the start, is to schedule out when the due date is under a contract, to put forward a cash flow forecast when they see the amounts to be due at certain dates. It's all by way of programs and it's all by way of forecasting. There's an inherent difficulty in the industry to do this. It's desperately important, but at those points, they will know what will happen. These are trends. The trends continue and they repeat themselves and they don't stop. And there is many solutions in respect of that because the consequences can be quite dire.
Yeah, I mean, okay, so I'm a business owner. I haven't been paid. I'm a bit woolly on the contract. When am I ringing you up then? Is it day one, day two? What am I doing?
It's always pre-contract. The one aspect about it is that when there's an agreement between the parties, and I'll just say, Sean, okay, when it gets to the courts, okay. Now, what we like to say here is that we always prepare as though you will end up in a dispute because your information will be so good, but without the intention of ever getting to a dispute.
Yeah.
It's that necessary detail that's required, but the time to think about this is before you go into contract. The contract is binding, the terms they can only be varied by agreement or any rectifications. That's expensive to do. Getting it right at the time and thinking about these points is key.
Is the problem, Laughlan, that it's an emotive issue because you're talking about money and maybe people, they don't want to have these kind of conversations?
I think that's a very good point, Sean. I think the other thing is that you might have a very nice working relationship with another party, and maybe after 14, 15, 20 years perhaps of a harmonious relationship, there is this bitter dispute about non-payments, and I think people are unwilling, as Henry said, to prepare at the front end. Now, on that point, I think it's a very good point about scheduling out payments, and one of the key points that arises from that is that if you have a payment schedule, common sense might dictate that the dates will just follow if the schedule runs out. For instance, if you are from, let's say there's 12 months in the programme for the works, by the time you get to the December pay date and you're still on site, what happens to the schedule?
Yeah.
You know, you would say to yourself, well, logically, the dates would continue in the same way. Now, they will do if you have got that amendment in the contract. If you haven't, then, as Henry discussed earlier, the implied terms of the scheme for construction contracts will kick in, and that has caught out quite a few people. And it was from a case a couple of years ago, and it's really something to watch out for, and it can be avoided with proper prior planning and assessment of the terms of the contract and making sure you know exactly what your rights and obligations are.
This phrase, Payless Notices, can either of you just walk me through this, what we're talking about here?
Yeah, ultimately, it derives from the Construction Act in that respect. One of the main instances is that a party, and I need to go back one step, Sean, if that's okay. It's important that a party actually knows what they're applying for. And while it sounds quite simple, in practice, it doesn't happen as much. And ultimately, a party will have to set out what they are applying for under the contract. If there is a variation, have they complied with the relevant sections of the contract? Have they actually put forward a notice? If it's a loss and expense, if it's deriving from a relevant event and relevant matters coming on as a result of a delay, what really needs to be set out is clearly what the party is actually seeking. How is it occurred, and is there an establishment or an entitlement in the first place under the contract to call upon those sums? Have they complied with the different provisions and set out? What then occurs is that under the contract there will be a timeline. Under JCT, it will be 5 days after the due date, there needs to be a payment notice. Many people refer to it as a payment certificate. And that will be issued by, say, the CA, the contract administrator, in those points. Now, it is up to the employer, not less than 5 days before the final date for payment, that they may, if they choose, issue a Payless Notice. Now, there's 2 points to a Payless Notice for an employer. If they don't comply with these 2 points, it may not be an effective or valid Payless Notice. It sets out 2 things. First is how much you intend to pay the payee, even if that sum is nil. And secondly, the basis of calculation. Now, that sounds very straightforward. In practice, it doesn't always occur. But if you intend to pay less than the amounts that are applied for, you need to comply with those 2 positions.
And have you had any examples of this, where this is, I mean, either best practice or where somebody has done this?
Well, the likes of the easiest way that if you're going to make an application or notify for sums due under a contract, either by a relevant event or if you are an employer and you want to pay less, the contract actually tells us. It gives us the words. And once you refer back to the clause itself, it's very much a case of follow that, and in some cases repeat what the clause says, and then more than likely not, you're going to be compliant.
Yeah. Laughlan, you represent companies on both sides of this argument. Is the advice the same? I.e., you do this, whatever side of the argument you're on, and you can't really go far wrong?
I think it's a good question. The answer is yes. Of course, we would encourage people overwhelmingly to administer their contracts in the most efficient and record-backed fashion possible. Records really will save the day when it comes to any prospective disputes. And Henry was quite right when he said that we would encourage people to have as many records as possible, because with that substantiation, you can very easily ascertain your payment. Now, I think a very interesting point on Payless Notices, and this is how the law has developed on it quite recently, is everyone does everything by email now, of course. In the JCT, you can communicate in writing. An email satisfies that test. Now, you need to make sure that if you are sending things by email, that the terms and any calculations in a Payless Notice are properly incorporated. Henry, we've dealt with situations where if an attachment has gone awry from an email, has that been validly served? Is that a valid notice? So the easiest thing to do is to make sure everything's all in one document, i.e. the amount that you consider to be falling due and the calculation for that. So to avoid any issues about service, you can try and make sure everything's in the same document. Yeah,
I mean, we've covered quite a lot of sort of technical legal ground here in the course of the discussion, but I just wanted to kind of sort of boil it down a little bit, really, if we can. I mean, in terms of top 3 tips for getting your cash, I mean, I know you've covered a lot of it sort of in depth, but crystallising it a little bit, what would each of your top 3 tips be?
I think the first aspect is to make sure that you keep up to date. It is not a solution to look at these points retrospectively. It costs phenomenal amounts of internal time, management costs, and if it is kept up to date and it is understood at the time of contract, going into the contract, how a company will actually go about these issues, because they will arise. They will arise again and again. And if they deal with these issues now at the very start, and how they're going to organise the records, how they're going to organise an up-to-date programme along with the cash flow, along with the works that have been undertaken, an up-to-date variation account, an up-to-date loss and expense account, with the necessary evidence to back those up, and to actually not wait until the final account to deal with these, when invariably the disputes occur.
So keep up to date one. Laughlan, what about you? Sort of brief points, really. What would you say?
So to summarise that, records effectively and efficient record keeping, and secondly for me, touching on what I've mentioned before, knowing what your contractual obligations are, making sure that even if you have all the records, you serve everything in the correct way, you adhere to your contractual obligations so that those records can secure your payment.
I mean, if things do go wrong and you get this sort of worst case scenario, I mean, realistically, how are you going to get your cash out? How are you going to get your cash back? Is this all going to end up in court, or do you think that by following these processes that you've outlined, you can head all that off?
Yeah, I think the ultimate point is litigation costs quite a lot of money. I think that better systems of training, understanding, and that starts from the top in many companies, and that has to flow to all of their employees. And if they follow these steps, it is more likely than not that they will stand a better chance. Now, there will be instances of insolvency, and I won't deal with that here when those points. But in most general cases, the reason why disputes occur is because of the level of evidence, the level of substantiation, and that's how disputes occur. By understanding those rules, you can actually hedge off the risk of a dispute occurring.
What's your final tip?
Well, the final tip in terms of what if you've got all the records there, what if you followed all of the obligations under the contract and the other side still won't pay? Well, adjudication is a nice alternative to litigation, and we certainly do a lot of that in terms of getting money for our clients. In terms of the time frame for that, you're looking at a period of 28 to 42 days from the date of the referral, which is the document that kicks off your kind of substantive arguments there. And of course, one consequence of even if you win, but you don't get the payment following an adjudicator's decision, then you can go and enforce that, and that is a very quick process in the courts. And that's a good way to cement your entitlement by way of a court order, and that would take you much less time than simply going through litigation.
Excellent. Okay, well, we're going to have to leave it there. So there's lots to talk about and lots to think about. And if you want to find out more or get in touch with either Laughlan or Henry or a member of the Silver Shemmings Ash team, then go to the website silverllp.com. Once again, thank you to our contributors, Henry Hathaway and Laughlan Steer, for joining us. And thank you for listening.